Okay, thank you very much for joining us today. We are talking about yes on 22, which is the state proposition about Assembly Bill 5. We'll give you guys some time for a brief presentation and then we'll launch into questions. So why don't you take it away?
Great.
Thanks for joining us.
Yeah, of course. And thank you for having us. Obviously, wish we could be together in person, but circumstances are what they are. And so thank you for agreeing to the time for us all to meet virtually. My name is Jeff Vetter. I'm the spokesperson for the Yes on 22 campaign. And I'll just offer up a high-level intro about Prop 22, what it does, and why our coalition believes it will protect jobs and benefit drivers. With me today is Al Porsche, an Army veteran and rideshare and delivery driver from Menifee, California. Kurt Onetto, the campaign lawyer, is also here to help answer any specific legal questions that you may have. Today, there's about 1 million Californians who choose to work as independent contractors with app-based rideshare, food, and grocery delivery platforms. By a 4-to-1 margin, independent surveys show that these app-based drivers overwhelmingly prefer to work as independent contractors with flexibility and control over their own schedules. 80% of app-based drivers work only part-time and rely on flexible work to supplement their income and provide for their families. Unfortunately, last year, Sacramento politicians passed AB 5, which threatens to make it illegal for app-based drivers to choose independent work. It comes at a terrible time when app-based driving is one of the only sectors where people can find new work. As I said, there's about 1 million Californians driving with app-based platforms at some point during the year. Of these drivers, 80% are part-time and drive fewer than 20 hours a week. And under an employment model, studies show that only about 100,000 drivers would be needed. That's a loss of hundreds of thousands of jobs. If Californians pass Prop 22 this November, it would save those hundreds of thousands of jobs, and it would protect the ability of app-based drivers to choose to work as independent contractors with control over when, where, how long, and with whom they work. Prop 22 also improves the quality of app-based work by requiring platforms to provide drivers guaranteed minimum earnings. Drivers would always receive at least an amount equal to 120% of the minimum wage, plus 30 cents per mile toward expenses. They would receive funding for new healthcare benefits, equal to an estimated $367 per month for a driver on average, based on the 2019 cost of a covered California Bronze plan. And that figure goes up as healthcare costs increase over time. Prop 22 would also offer disability coverage for injuries and illnesses on the job and protection against discrimination and sexual harassment. Most importantly, I think, Prop 22 would ensure the availability and the affordability of app-based delivery services that millions of Californians now rely on to bring groceries, medications, and warm meals to their homes, while helping small restaurants and retailers connect with customers during this era of social distancing. With that, I'll turn it over to Al Porsche, who's a rideshare and delivery driver, to talk a little bit about his background in rideshare driving and why he's supporting Prop 22.
Thank you, Jeff. Hello and good morning. My name is Al Porsche. I'm a driver for Lyft, but I'm most proud of being a veteran of the United States Army. The Army offered me the opportunity to serve my country and to defend its freedoms. While not exactly the same, I do feel the same sense of pride in serving my fellow Californians when I drive, helping them get to work or job interviews or medical appointments, especially as the state goes through a difficult time with the pandemic and recession. And right now, I have the freedom to choose when, where, and how I work. As we approach this important election, I'm reminded that the freedom that hundreds of thousands of app-based drivers have to be independent and work when and where and how long we want is threatened. Sacramento politicians want to eliminate the ability of California drivers to work independently and force us all to be employees, even though we don't want that. Their actions will eliminate hundreds of thousands of jobs, and that's why so many drivers, more than 100,000, have signed up to actively support Prop 22. So when lawmakers threaten the jobs of app-based drivers by forcing employment status on us, the people hurt the most are Black, Latino, and Asian Californians, communities that are already reeling from the effects of COVID-19 and the collapse of the economy. That's one of the many reasons why, by a 4-to-1 margin, an overwhelmingly majority of drivers want to keep their independence. It's also why so many drivers of color, social justice organizations, business groups, and community leaders are urging Californians to vote yes on Prop 22. Thank you.
Is that, I see Kurt's on the call too. Is Kurt speaking or?
Nope, Kurt's
Okay.
here to help answer questions.
Just here
Perfect.
for questions. Thank you.
Perfect. I appreciate that. Let me ask you, just jump right into this. The San Francisco Chronicle has already endorsed in it, and they had a line in its editorial that really struck me. It was, this is two determined and equally unappealing combatants, right? So on one side, you have companies that have the wherewithal to spend $180 million on this to share their companies. Let's be honest. On the other side, you have labor unions and the politicians that they give a lot of money to, trying to uphold workers' rights. So I guess my question for you is, this board opposed AB 5. We said that it should be handled on a kind of case-by-case basis. We fully recognize that there is a legal reason to address these issues, but are troubled by this, not only for its AB 5's effect on journalism, right, personally, full disclosure, but also its effect on these gig economy companies that a lot of us use all the time. It's hard to imagine California without these companies. But I guess my question is, why shouldn't and couldn't this have been done at a legislative level where the nuances could have been addressed? Instead, it's this black and white, either or situation, which is, this is a too complex a subject, right, for this. So I guess what do you say to that issue, and why couldn't we have gotten this done in Sacramento?
Sure, I'll start, and then I'll see if Kurt has any additional comments. I think the biggest challenge is that politicians in Sacramento refuse to listen to what the majority of app-based drivers were saying. They've been warning for more than a year now that under an employment model, these opportunities to earn an income, these hundreds of thousands of jobs would disappear. And what you've seen over the last year is more than 100 carve-outs or exemptions to AB 5 that have been granted to a variety of industries, professions, and occupations. But so far, the legislature just has refused to listen to the concerns of app-based drivers, to hear their opinions on ensuring that they have flexibility, that they have the option to choose when, where, and how they want to work. So I understand the premise of your question and agree to an extent that it would be nice if the legislature would take this issue a little bit more seriously and listen to the drivers, but unfortunately that just hasn't happened so far. And so what our campaign has done is actually talked with thousands of drivers and listened to what their concerns are. And what we've seen as a result in Prop 22 is a reflection of what drivers want. They've said the most important thing for them is ensuring that they have this flexibility. As I said, the vast majority of drivers work only part-time, less than 20 hours a week. And they do that because they're students, they have other jobs, they may be retirees. Some may do this work a little bit more more towards full-time, but even full-time drivers say that they want this flexibility to choose when and where and how they want to work. And unfortunately, under an employment model, that would disappear. The other things that drivers said that they wanted were guaranteed minimum earnings, which we've reflected in the proposition with the new earnings guarantee of 120% of minimum wage, and then access to some type of healthcare benefit, which is, again, what is provided under Prop 22, with healthcare benefits starting at just 15 hours a week and then escalating up to the full 100% employer contribution at 25 hours a week, which I'm sure we'll get into healthcare a little bit more in this conversation, but those benefits are more robust and generous than what you see in most traditional part-time employment. Kurt, is there anything you'd like to add?
Yeah, just very quickly, I think it's important to note that there was an extraordinary effort made by the app-based companies and coalitions of app-based drivers in 2019, prior to the adoption of AB 5, to try to get the legislature to move to a situation, to a model that was, as you said, Matthew, more flexible, more workable, more reflective of the 21st century world and economy we live in here in California. And unfortunately, the legislature simply wasn't willing to budge on those points for the reasons I think you articulated it. Their primary supporters in organized labor weren't willing to budge on those points. And that's why we have, that's really why we have the referendum, or the initiative referendum process. If if the legislature was doing its job back in 1911 and not letting the railroads call the shots, we probably wouldn't have the initiative process today. And if the legislature was really being responsive to the needs of hundreds of thousands of drivers and the millions of Californians that they support with the services they provide, we probably wouldn't have Prop 22 either. But unfortunately, that was the choice the legislature made. Could it have been worked out? Theoretically, yes. Was the legislature willing to do so? No.
Do you worry that if it is passed, that there will be future litigation and that we're gonna have to do all this over again because it doesn't meet the letter of the law?
What do you mean by that?
Well, based on the legal precedent that got us into this snafu in the first place.
Well, I'm quite confident that the law upon which the court decisions and AB5 were built will be superseded by Prop 22. That's what the purpose of the initiative power is, of course, is to give the voters the opportunity to step into the shoes of the lawmakers when the elected lawmakers are being unresponsive to the needs of the citizens of the state, and enacted their own law, which is what voters and drivers are going to do here.
Mm-hmm.
So no, I'm not concerned. I think once Prop 22 passes, I'm not concerned about invalidation through the courts.
How about the PRO Act on a national level? If you guys are spending 180 million in California, what's that times 50? Are you worried that the PRO Act is going to upend Prop 22?
Is that the measure introduced in Congress, or?
Correct. Yeah. I mean, obviously, that you're making big assumptions that it will even get passed in the Senate and go to the president's desk and have a president who would sign it. But if it were, like, what is the fear there that we're going through this exercise only to be upended at a national level?
Yeah, my response would be, we can't control what's going on in Washington. I don't know if anybody can. Today we have a problem in California that needs to be solved because there's hundreds of thousands of drivers that could lose the access to this work, and millions of Californians that rely on it, especially during the pandemic, to get medicine and food and things like that could be without. So we're focused on that, and I think, and I'll let Jeff speak for it. I think once Californians speak out strongly, in terms of their preference on this issue, which we're confident they're going to do in November, we think that will send a message to the rest of the country of what the public wants and needs in this area.
Mm-hmm.
Yeah, and I'll just quickly add, there's a lot of hypotheticals involved in that question, and so I think Kurt's right that we have an issue right now in California, and that's what we're looking to address through Prop 22, and we'll have to see how those hypotheticals play out over the next weeks, months, and years.
What I've been struck by in this whole debate is how little the advocates of AB5 appreciate the fact that these jobs are often second jobs for people, and people who already have health insurance, people who already have benefits. And I'm one of those. I lost all my gigs as a freelancer because of this. And I was told that, oh no, it's being done because it's good for you. So I think you guys have the moral high ground in this. On the other hand, we ran an op-ed that said this bill or this measure has only superficial benefits for people for health problems that they get while driving. So would you address that?
Yeah, and you're referring to sort of the occupational accident insurance that's provided under Prop 22. Kurt, I don't know if you want to get into specifics here, but just from a high level note, the occupational accident insurance that's provided under Prop 22 is very similar to workers' comp style insurance, and I think particularly relevant given, again, the nature that the majority of this work is done by part-time individuals who work less than 20 hours a week. But Kurt, I don't know if you want to address that in a little bit more detail in terms of.
Sure, just I think it's a great point. Prop 22 does provide occupational accident insurance to cover injuries and illness on the job that is extraordinarily similar to the workers' compensation structure. It provides benefits for 104 weeks or 2 full years on the same basis as workers' compensation. Now, the one difference is you could argue that it doesn't provide for permanent disability payments. However, the other thing that's a difference that people, I think, who look at this rationally understand that drivers can, there is no limitation. If you have a job and you're employed and you have set shifts, you can sort of prove where you're at and who you were working for when the injury occurred. That's very hard to do in a situation where app drivers can literally bounce from app to app to app, within multiple times within the same hour. So the point was to provide that baseline safety net for folks, recognizing that they're usually doing this, as you point out, as a part-time secondary job, but it still recognizes the fact that drivers need and deserve real benefits for injuries on the job, but it does so in a manner that continues to recognize the sort of the independent, flexible nature of work. That these drivers have much more control over their own lives than an employee would, and that's part, frankly, of that's just part of the give and take when you maintain maximum flexibility. If you're an employee, sure, your employer could put all kinds of additional safety restrictions on you and tell you where you can go and where you can't go, what you can do, what you can't do. That's not available. That would defeat the purpose of independence, right? For the drivers and under an independent contractor model, that maintain the flexibility. So it strikes that right balance of providing, a really generous benefit, frankly, but not going so far as to create a situation where the companies would need to start exercising significant control over the drivers to try to, avoid those sort of situations where they think that there could be additional liability. If that makes sense.
Al, what do you do for health insurance? Are you is this a secondary job for you, or is this your primary work?
I'm retired. I retired in my 30s, and I have my own health care.
Okay.
Yeah.
I think I think I'd like to go back to the messaging on both the campaigns. Another one of these ballot propositions that's a little hard for people to understand without actually reading the proposition themselves, and if they're relying on the messaging from the two organizations that are saying yes and no. So if we could go back to the message of the no people, which is drivers are being abused, drivers are being taken advantage of. This is a slippery slope. I mean, what's next? Will we have coal miners that are contract workers rather than getting the types of benefits that people fought long and hard to get? How do you address that messaging, and how are you going to get your message out that those aren't relevant arguments?
Sure, and I'll let Kurt jump in to see if he has any additional thoughts, but the way that Prop 22 is structured, it's very specific to app-based rideshare and delivery drivers. So there's no real possibility that the language in this measure could be broadened to incorporate other types of employment work, to say that these are gig workers and so should be treated as independent contractors. And the one thing that I think is a little bit ironic in all of this conversation is one of the things that we hear, and I'm sure we're going to get into this at some point, is that the opponents will say that the amendment threshold in the proposition is so restrictive that it can't be changed by the legislature without a supermajority, but also that it's going to be changed to apply to a variety of other industries that are not currently covered. And frankly, I don't think both of those things can be true at the same time. So I'll let Kurt speak to this in a little bit more detail, but there's no possibility that Prop 22 could be broadened to incorporate other industries or areas of work outside of app-based rideshare and delivery drivers.
Yeah, Jeff's absolutely right. I mean, legally, it is a bright line in Prop 22 who's covered. There's a clear definition of a driver, and there's a clear definition of rideshare and delivery services. And that's all that is covered. So any other lines of occupations simply can't be, you can't take that square peg and shove into this round hole that's created in Prop 20. It's just not possible. That is an argument with zero merit. The slippery slope, it's a non-starter, frankly. The way the measure is so clear on it only covers app drivers. and only covers out drivers who are performing rideshare and delivery services, which are tightly, there's even, mileage limitations on how far a delivery can be to maintain an app-based driver status. It can't be long haul truckers, right? Because it's limited to, I think it's 50 miles. So there's not even a possibility that it could be expanded to other types of delivery and rideshare services other than the ones that we're familiar with and that we all sort of contemplated in this area.
I have a question for Al. When you made your presentation, you mentioned that a lot of the drivers were people of color.
Yes.
How did you collect that data? How do you know how many seniors or students or Black, Brown, Asian? How did you come up with that data?
When we have gatherings, or not a gathering, before COVID was COVID. We used to have rallies or drivers gather and voice their opinion on Prop 22 and what benefits it offered and how it supported their life and their communities. And within those conversations, that's what I've gathered for myself, that most of the majority of the drivers were of different descent.
And Laura, if I can just add on that there's internal company data from companies like Uber and Lyft that suggest this, as well as independent studies that will show that the vast majority of drivers are people of color. Happy to send that over to you, Matthew, if you can be a conduit for the board, but happy to get that over.
Thank you.
Thank you.
So what would happen if if it doesn't go your way?
Yeah, and so what we know would happen under an employment model is a few things. One, the vast majority of drivers, like I mentioned, who work part-time, 80% work less than 20 hours a week. We know that there would be a loss of hundreds of thousands of jobs. That's for a couple of reasons. Number one, as we've talked about, that flexibility is the key issue here. That's the primary driver of why people seek out this type of work. So if you remove that flexibility and say you're now going to be working set shifts and schedules, there's a large number of drivers who do this currently who would choose to no longer do it. The people who are driving part-time primarily. Secondly, what we know is that it would increase impacts on consumers. So you would see longer wait times. An independent study found that wait times would potentially double, as well as the cost of rideshare and delivery services would potentially double as well. So you would, in addition to seeing fewer drivers on the road, because they would have to limit the number of drivers who are available to meet demand during certain hours, so that's why you would have longer wait times and higher prices, then consumers would likely decrease their use of these types of services. So you start this downward spiral where you have fewer drivers doing this work. The services are less convenient and efficient and more expensive. And that creates a positive feedback loop where fewer people start using the services, and it adds to more and more job losses, which increases the cost and wait times further. So in a nutshell, what we would see is hundreds of thousands of jobs that would be lost, and the cost and wait times of these services would be impacted greatly. And also we would likely see a significant reduction in the availability of these services outside of your core dense urban areas of the state. So your downtown areas of San Diego, Los Angeles, Sacramento, and San Francisco, and Oakland area, they would likely still continue to have services, but your more rural and suburban areas of the state where there is less demand would likely go without services.
And final question for me is, what would you say to the argument that the real beneficiaries of this are the app-based companies themselves, not the drivers? That the companies want this because they'll make more money from this process than by the one that's covered by current law?
Well, what I would say is very simply is the nonpartisan legislative analyst office looked at what the fiscal impacts of Prop 22 would be, and they found that it would lead to increased earnings for drivers. And so what I think you would see coming out of a successful passage of Prop 22 is that drivers would be earning more money. They would They would maintain the flexibility that they want to choose when, where, and how they would want, how they want to work. Their earnings would increase, and they would have access to new healthcare benefits. And so I think, one of the things that's lost in this conversation a little bit is that with Prop 22, we have the opportunity to pass a win-win. This would be good for the drivers who do this type of work because it protects their flexibility, increases their earnings, and provides access to new benefits like healthcare. And it also benefits the consumers, everyday Californians who rely on these services right now, people who are trying to get medicine delivered or food right now, and also the small restaurants, retailers who, because of this pandemic, because of social distancing, don't have the option of having people come into their stores or their restaurants and eat or dine or buy things there. They have the opportunity to reach customers right now because of these delivery services. And so I think everyone would benefit from passage of Prop 22.
To add on to Jeff's point, maybe we're going to get into this. Some of the benefits in Prop 22 are more generous to the drivers than would be in healthcare in particular. We all know what happens in large sort of retail employment settings and the big box retails where you get, federal law requires healthcare insurance to be provided at 30 hours. So you can go to any Costco or Walmart and you can find a whole bunch of people who are working 25, 26, 28, 29 hours a week. Not getting health insurance. Prop 20, and their employer schedules them that way so they can't work more, so they're not entitled to health insurance. Under Prop 22, drivers can start obtaining a mandatory healthcare benefit at only 15 hours a week, full benefit at 25 hours a week. And importantly, in addition to that, there's no way for the app companies to control the number of hours that the driver works. If the driver wants to obtain that benefit, they're not on a set schedule where they can be told, no, only work 14 or 24 hours so you don't get the full benefit. It's completely within the power of the driver to decide if they want to get that benefit or not. And there's no way it can be basically withheld from them by manipulating the set schedule. That's a substantially greater benefit that they would get. So to say that this is just a win for the companies, this is not borne out by the facts of Prop 22.
And I'm curious, Al, how many hours a week do you end up working for the various rideshare apps?
Between 20 and 30 hours, depending on it. Also, if it's a holiday or a special event.
But isn't that a good point though? So that's not 15, 25 hours for one company. I have friends who are drivers who drive for 5, 6 companies. So in theory, you could get 10 hours at 5 companies and still not get your health benefits, right?
Yeah, and that's half true. Prop 22 tries to accommodate for that. It looks at the hours worked on a platform over a calendar quarter. And you just have to average 15 hours over a calendar quarter for a particular app to make sure that exactly what you're talking about, Matthew, doesn't disadvantage drivers. So a driver, if they're just driving 10 hours, for 2 weeks on a platform, right? Then that last this first 2 months, the last month they can drive a little more, they can go a little heavier on that platform, get their hours up to the 15, 25, whatever their personal goal is, and make sure they benefit. So there is, we took that into account that there is sort of, the cross apping or whatever that's called. And we wanted to make it absolutely flexible. Prop 22 is all about flexibility to make sure that the drivers even can have control over that so they're not stuck into, hey, if you missed your hours on 1 week or 1 month, you're out, you don't get the benefit. No, you have a full calendar quarter to level it out.
Right.
And just one thing that I do want to add, because I think it's a really important question. On the other side of that, if you were to work 15 hours for 2 different apps, let's say, you would then qualify for that healthcare benefit from each company.
Yeah, you could double it up.
That's right. So if you were to work 15 hours for Uber and 15 hours for Lyft, you would be provided that 50% contribution for both companies, which would then total up. And obviously that would escalate if you were to work 15 for one, 25 for other. If you do this more full time, you would receive more in the stipend. So again, it accounts for the work that you do across multiple companies.
Great point, Jeff. Thank you for raising
that. Go ahead, Evie.
Okay, you all have described people getting their medications delivered to them through these app-based services. How is that exactly happening? And is it just over the counter, or are people getting their subscriptions this way, or prescriptions? I'm
Yeah, Al, do you have any experience with delivering? I think there's the majority of this is likely through over-the-counter medicines.
Yes.
Although I have heard anecdotally of various pharmacies utilizing some of these services to deliver prescriptions, especially for patients who are immunocompromised, who are concerned about potentially going out. But Al, I don't know if you have any experience with delivering some medications that you want to share.
Not precisely. However, I do get orders through Instacart via CVS or Rite Aid and Walgreens.
One of the criticisms. Oh, sorry, Laura. Go ahead.
Tomorrow, we're going to be publishing an op-ed from an author who's writing about auto emissions and the governor's recent announcement about trying to keep, smog out of the air and less cars on the street. So have you been questioned about that? And what would you say to environmentalists who are concerned about so many cars that are not electric cars are safe, emitting safe auto emissions out on the roads in California?
Yeah, and I don't want to speak for the companies, but I actually had a conversation with a driver very recently who talked to me through a new credit that Uber was providing to help drivers purchase electric vehicles. So I think this is an area where the various companies are aware of exactly of this type of issue, that we need to do more to make sure that we have clean air going forward, and that we meet these standards as they approach. And so I think the companies are willing to be a partner in making sure that we meet that. But yes, this is something that has come up in the past. And, I think what rideshare provides is the availability of accessible transportation, especially for people who don't have access to a car. And I think what could happen under a situation where we remove the ability of rideshare services to operate in California is you would likely see an increase in people buying cars. And so there would actually be more cars on the street if you remove the availability of these types of services, because people are going to need ways to get around. And if there's, reduced access to public transportation services, which is what we've seen right now during the pandemic, if rideshare is not a viable option, people are going to do what they need to do to get around. And so you'd likely see an increase in personal vehicle use.
One of the criticisms I've heard is just about time spent unengaged by drivers looking for rides. And so how much time on average is spent? And when you factor that into the time they do spend driving, like what do wages look like then?
Yeah, I'm happy to handle the second part of that. Al, do you just want to talk a little bit about your experience in terms of what your wait time between rides are?
Yes. No, my experience with the wait times is far and few between, because basically what I do is I wait in between the hotels and airports. I go where the areas and the ride requests are areas of saturation, and the ride requests are high. And according to one of the different platform that I'm on or that I'm online with, it advises me or gives me notifications in advance before arrival where the requests are high. So therefore, while I'm waiting, it's between 1 and 2 minutes, 3 minutes max. And most of the time when I turn to my app, I immediately get a ride request.
And then I'll just pick up, because I think this question over engaged time is important. And so what Prop 22 would do is compensate for what is called engaged time. And engaged time is the time that's spent between when a driver like Al accepts a ride or a delivery on their app to the point of where they pick up the passenger or the delivery, and then through the completion of that trip. So this is compensating for the time that drivers actually spend on their trips or deliveries. And one of the things that I think is why that's incorporated in there is a little bit of common sense. No business can afford to pay workers for time that they spend not working. And so it doesn't make a lot of sense to compensate people for simply having an app open. If I could sit and have an app open all night, I think people, without actually doing any trips, I think there's lots of people who would do something like that. And you also need to look at how do you compensate when you provide the opportunity to do cross-platform work. So if I have my app open and I'm doing rideshare trips for Uber, and I also have my app open for, let's say, DoorDash, and I'm doing deliveries there, should I be paid for both companies for the time that I have the app open if I'm only doing rideshare for Uber? The last part of this is, I think, this is the way that you protect that flexibility that drivers said that they want. Again, if you compensate for all the time that a driver spends on an app, you'd need to exert some control over that. So you would need to require drivers to accept essentially every ride. If you're going to be compensated for all the time that you spend on an app, you need to be required to accept every trip that comes across your way, which again just eliminates that flexibility that drivers say they want. If they have to accept every single trip that Uber sends them, you've just made them an employee, which is again what the vast majority of drivers say that they don't want.
Another question I have is just about, I've heard good days are good, bad days are bad. Is it always possible to get 15 hours, 25 hours in a week if you want to as a driver?
Yes. Yes, it is. It's possible.
Where are you a driver, Al?
Yeah, in the San Diego area, 90% of the time, and other times I'm in LA or Orange County.
How many hours a week do you average?
25 to 30 or more.
And is that in multiple apps? I assume you do. Like, how many do you get on the app you use the most?
How many hours or how many trips?
How many hours? Yeah.
Oh, how many hours? 20. The last I had was 27 hours.
Oh, okay. For a single app. Mm-hmm.
For one app, yeah.
Okay. Okay.
When I was in Las Vegas last year, the Uber driver that I had said that the number of hours he drove was entirely dependent on whether or not he had a girlfriend. And I just thought that was like a striking example of how modern life is that if you have these app-based attempts or app-based availability to work, it colors everything in your life. And so it just seems to me that in some ways that you guys are representing the future and the opponents are representing the past, if it's so fundamental to how people deal with their lives.
Yeah, I'll just quickly point out that I think one of the things that we're trying to solve for in this situation is recognizing that we are talking about a 21st century type of work, that this is, although it's a little bit ubiquitous, and I don't think a lot of us can remember a time before we had access to services like Uber, they're relatively new in the grand scheme of things. I think, within the last 10 years, these services have come on the market. And they are so prominent because they've filled a need, that there was a recognition among a lot of people that taxis were not as efficient or effective, or in some cases discriminated against particular communities, and rideshare services filled the void. And what we needed to do was recognize that this is a very new type of work, and so we shouldn't be applying 20th century solutions to a 21st century problem.
Talk a little bit about the money in the campaign. I mean, you by a factor of 18, you have so much more money than your opponents. Are we just going to see I don't expect you to share your strategy, but are we just going to see a blizzard of television ads? Is that the campaign, or how does the campaign unfold in the next 4 weeks?
Well, I think you're going to continue to see a lot of direct voter contact between now and Election Day, which I think is just about 4 weeks away from today. And the reason for that is, I think, really simple. And we've talked a lot about these issues already, but there's really high stakes in this election. Again, we're talking about hundreds of thousands of jobs on the line. We're talking about these services that millions of Californians rely on now more than ever during this pandemic. And so those stakes are really important. And, there's 10 media markets in California. There's 20 million 21 million registered voters, I think was the most recent report that came out yesterday. And so it's really, really important that every Californian understands exactly what's at stake in this election, and that unless Prop 22 passes, that these jobs and these services could be gone for good.
Can I raise one point on that issue? Since it's something that this editorial board has talked about before, and it's, as a lawyer on the team, it's kind of near and dear to my heart. The Attorney General, in his ballot summary for the measure, he drastically changed it for the ballot from what the original summary was presented when the measure was filed. The first go round, it was very fair and neutral. Something got to him and changed his mind on this measure and a few others, where he drastically threw out the original neutral draft and started over. and completely wrote a biased, unfair, and frankly inaccurate title and summary. Unfortunately, the legal standard for challenging those is so overwhelmingly high that it's virtually impossible. So he gets to do whatever he wants. So I would point out that whatever the dollar ratio is between what the yes side and the no side has, it has been equalized to a great degree by the official state actors who, who in line with the legislature and the folks who supported AB5 have done in the ballot summary to attempt to, in my view, and this maybe speaking for myself here, not the campaign, to create bias against the major to the maximum extent possible. I think that this editorial board took the Attorney General for task on Prop 22 and maybe on Prop 15 on this very issue. So just closing the loop on that point, I think that's something important to keep in mind in terms of the economic disparity between the campaigns. It's not maybe as great as is indicated on in dollars when you take into account that the official support behind the scenes support that the other side has received from the Attorney General.
Yeah, we've been taking attorney generals plural to task for that for years.
Absolutely. Thank you for that. Please keep doing so.
Okay, this was a good discussion. My questions have been answered. Does any last questions from the board? Or any last points that you guys want to make? I think we covered the waterfront, but if there's no need to repeat anything you've said, but if there's any other points that you haven't made that you'd like to go for it.
No, I thank you for your time, and would just encourage voters across the state of California to visit yeson22.com to learn more about why Prop 22 is essential to save app-based jobs and services.
Okay. Thank you very much, Al, Jeff, and Kurt for joining us today. Appreciate it.
Thanks
for your time.
Take care.
Thank you.
Thank you.
Bye, everybody.